could be an intellectual, academic concept, and I know I'm one of the few people with 2 masters here. We could engage in intellectual discussions of what the concept of public interest means, but at the very bare minimum, public interest means the reaction of the public to an event. So my lady, I'm not quoting the intellectual bit. I am quoting the simplest on the street. If we went to the Obunga and Buta market, I hand over to my colleagues.
To withdraw the question of masters.
I have withdrawn.
He might be embarrassed.
I did not hear. I did not hear. The court hears and some it blocks. Did you? Yes, yes. Mr. Witt, it was a yes.
I know Mwalimu is here. He was my teacher by osmosis.
Okay, how many minutes, Mr. Ondim? Modus operandi. Once plea has been taken, all accused persons are remanded in prison and not at police stations. Police stations are temporary holding cells where suspects are held for 24 hours before arraignment. Suspects may also be held for a longer period pending investigations where a miscellaneous application has been filed. That is not the case before me.
That we shall lay the deceased to rest on 4th of July, that is next week, Friday. You are all welcome to come on the rest. So help us lay to rest. Thank you very much.
The head of probation, are you in court? Probation, Kibera? Yes, come forward. The practice of this court is always to have the whole day. That's what we've been dealing with. Now, these are 6 accused persons. How many days do you require to prepare the pre-bail report?
The lady give us 1 month and 2 weeks.
No mamas, no mamas. The court is writing. You are interfering with the flow of thought.
The lady have said.
Yes, I heard you. I'm talking to my friends around this corner. They are murmuring.
When you have the law, pound the law. When you miss, pound the table. So please pound the table. Yes, let him pound the public interest.
Thank you. So you did not pound facts, neither did you pound the law, you decided to pound the table?
No, yes, that's me to pound the table.
That is what goes on record.
Right. Thank you very much. You have really taken a short time. I now go to the advocate for the second accused. And say the name again.
My lady Chisengo Spagen. Appearing along and that will take a very short time. And I want to begin from where Daniel Senior ended. That the prosecution has not went to him, arrested him, or maybe he was running away. That is not true. The second accused person presented himself to IPOA to record a statement. My lady, in paragraph convening prisons to deny the second accused person bail. My lady, I'll go to the affidavit. And they have said that that the accused person is likely to interfere with witnesses. And as counsel has submitted, we do not know the witnesses. The accused person. My lady, I want the court to take judicial notice that the second accused person is a police constable. He's not influential. He leads a normal life. And the only crime he committed was to be on duty, as per the duty rota. My lady, they have said that
bail terms of an accused person, the right to liberty and dignity of an accused person are fundamental human rights that are not granted by any law, and are actually protected by the Constitution itself. We submit, Your Ladyship, that to deny the third accused person bail on the ground of the seriousness of the charge against him would effectively be a presumption of guilt against the third accused person. And we humbly submit, my lady, we do, of course, understand the nature of this, the public interest nature of this charge. And we do empathize with every person involved. However, it is our humble submission for submit that bail must ultimately facilitate pretrial attendance and not serve as a pretrial detention. The Ladyship, in conclusion, all that we've gathered, the counsel for the third accused person, from the affidavit opposing bail, is that the depositions therein are merely vague, generalized intentions, which this honorable court is being invited to act on to deny our client the constitutional right to bail. And we have the submissions of the LSK, and our submission again, Your Ladyship, is that a majority, rather a substantive part of those submissions, hopefully belong to the mitigation aspect of these proceedings and not for purposes of bail hearing. We submit that no tangible evidence whatsoever has been demonstrated, rather has been given to demonstrate the existence of compelling reasons to deny the third accused person bail pending his trial. We remain obliged. Thank you.
Let us encourage ladies to come into the court.
What did you say? And who is seated here?
Judges, you are doing very well. We encourage them to be part of us. Wait, don't tell them. I know when you improve even the class.
Are you for the fourth?
For the fourth.
For the fourth.
Yes, Your Ladyship.
And fifth?
Fourth.
Only fourth.
For the record, Mr. Black Omanga. Your Ladyship.
Ladyship, it's very difficult to submit after some of my colleagues, but I'll attempt to proceed.
Yes, you do not need to repeat what you have said.
Very well, very
You
well.
can actually just say what you said.
Very well, Your Ladyship. I was just saying that I'm impressed by their submissions, so that I know that my attempt to shine may not succeed anymore.
Justice. Thank you very much. Please go ahead and shine.
I'll try to limit myself to just 2 aspects.
Yes.
Because I'm persuaded that brevity is the soul of it.
Yes.
I'll only focus on 2 issues, on the compelling reasons, on interference with witnesses, and public interest. For the 4th accused person, there has been an allegation that while in custody, he was referred to as Kinara. Kinara refers to a leader. When that was mentioned, the first thing that ran in my mind was a quote by the well-known Mahatma Gandhi. He said that, I suppose leadership at one time meant muscles, but today it means getting along with people. As a leader, I believe is there to guide the detainees on the right path and not otherwise. That should have worked for him and not against him. Your Ladyship, if I may, when I had a look at paragraph 45 of the sworn affidavit, they attempted to talk on rights of particular persons, including victims and witnesses, but they deliberately excluded rights of the accused persons. What does that tell us? We can answer it later on. Your Ladyship, I'll refer to the case of Dwight Sagarai, in as much as many counsel have referred to it, and again attempt to say something on it. In this case, we're told that the prosecution must prove that there has been that said interference. And how do they do it? They have to demonstrate that there has been communication, whether directly or indirectly, by any of the witnesses.
Demonstrate that?
They must demonstrate that there has been communication between an accused person and any of the witnesses. This has not been demonstrated, despite the fact that they allege that the accused persons were detained by together with potential witnesses. Again, still, in this case of Dwight Sagarai, the learned judge talked of the proof that there could be any close familial ties or relationships between the accused person and the witnesses. This has not been proved at all, that the 4th accused is having any family ties with the witnesses or even the victims, Your Ladyship. Your Ladyship, we are also told of threats. Having looked thoroughly through these affidavits, there is no threat or any allegation of threats that have been talked about in the affidavits. I therefore don't understand why there are allegations of interferences with witnesses. Your Ladyship, if I may, we are also told that under paragraph 42 and 43, because of time, they're attempting to talk on public interest. And I was surprised by the assertions of my president, who is unfortunately no longer here with us. On the president was trying to speak and say that tomorrow there could be issues within the country. Your Ladyship, as advocates, even when you address the court, it's clear that some of us are politicians.
My lady, to be opposed to that
Yes,
line
yes.
of submission, if counsel could refrain, the president is not here.
You represent the president. She who left
She's
no longer here. Yes.
No, that does not stop him from commenting. He is responding. We can't call her to come back. Proceed, counsel. You have not said anything offensive.
Thank you.
Yeah, proceed.
Well, you're very fair. I wish you'd make your ruling today.
So it would be unfair to the president.
Yes.
Let me just mention this, even if it doesn't go. Let me finish first.
You cannot have what the judge
Counsel,
has.
you
cannot be on your feet.
Counsel, let me just finish saying what I'm saying. Even if you don't like it, then the court will rule.
No,
but
you cannot.
The court has already ruled.
My lady, what I'm humbly requesting. The court has ruled. This counsel mentions that he is surprised that some of us are politicians. The president is not here.
I haven't recorded that yet.
Yes, so that is the problem which they have. So
there will be issues in the country tomorrow.
Yes, and then he adds that he's surprised that some of us are politicians.
Speak for the DPP. Watch out.
I think it would be unfair to the president.
That noise is what created the DPP of the
Mr. Omari, you look like a village elder.
My age, I am there.
Thank you very much. You cannot stop him to reply to what the president submitted just because she has walked out. It is a record. It is a court record. It will go to the Supreme Court as a court record. No one drove the president out. She had a bad cold. However, the president is ably represented by two counsel in the House. If need be, they can counter. Remember, you are going to counter. Sit down, give him time, or else I'm resilient enough to keep you here up to 8. That is up to you. Now proceed.
Thank you so much, Your Ladyship. And kindly, I appreciate your protection from Xavier, which is too harsh on us.
I'm sorry.
No. He's just a very bright young man. So he's just a bright advocate and very passionate. And so and very, very zealous. So no problem.
Very well, Your Ladyship.
My apologies, my lady.
Apology accepted.
Very well, Your Ladyship.
Okay,
And I really appreciate your direction.
Okay.
Going forward on to paragraph 45.
Yeah, you see, the theme of politics is not in the proceedings.
Thank you.
Yeah, left out. Proceed now.
Your
Yes.
Ladyship, I'll get back to that. I think it should come at the tail end.
When you get back to it, remember not to politicize the
Very well.
report.
Very well, Your Ladyship.
Yes.
I will not. I'll
Yeah.
just stop on public interest. Because
Yes.
Very well. Going to paragraph 45 of their affidavit, you notice that a clear reading, perhaps somebody can assist Mr. Xavier Whitty with that. It reads out, Your Ladyship, this Honorable Court has a constitutional obligation to uphold and balance the rights of all parties, including the rights of victims and witnesses. It would be in the interest of justice that the accused persons are granted bail at the stage of these proceedings. Kindly, I know counsel might be tempted to say something on that. They accept that the accused person should be granted bail. Under paragraph 45, they can confirm that. So, in as much as we are trying to go up and down with all these, I think we would have rested with arguing on conditions or terms that are supposed to be put in place, rather than arguing on whether or not they're supposed to be granted bail. Whoever saw these affidavit stated clearly that they see that the accused persons have a right to be granted bail or bond under your paragraph 45. As we proceed, Your Ladyship, we were speaking on the public interest, where I stated that some of us, I was not even referring specifically to the President of the Law Society of Kenya. Some of us are politicians. Myself, I'm a politician, and some other lawyers are politicians. When we speak about politics, we know it's in the public interest. When somebody swears an affidavit and states that there would be public anger and threats to their safety, to be clear enough, we would state that how many people in the public know about the accused persons who have been arraigned here before the court. The question would be, Your Ladyship, I'm tempted to reason out that we are attempting to sacrifice the small fish at the expense of the big fish. When we talk about the public being raged and having to demonstrate tomorrow, the demonstrations are not because of the small fish.
Maneli, do you want him to continue?
No.
We object.
No.
Mr. Omari, we object.
I am here to represent the DPP. I object to that line of argument. It is on the basis of facts which we don't have. We do not know what will happen tomorrow. Give us those facts so that we go and investigate and come back. My lady, we object.
I sustain.
Yes.
Objection sustained.
Your Ladyship, I would refer the court to section 59 of the Evidence Act, whereby courts can take judicial notice of certain aspects.
And then the objection has been sustained. Counsel should just drop it.
Okay, let's let him say the statement.
We don't know which kind of fish he's referring to.
No, I already sustained the objection. If the fish has come from your mouth, let him say it. You want to bully the advocate, let him say it, and then I will sustain and expunge. Proceed. Whatever you say, if I have already said do not go that route, I'll expunge from the record. Thank you for your humility.
I'm trying to buttress my argument.
Everyone knows what you're trying to say, and the court has said no.
Very well, Your Lordship.
Yes.
I'm trying to refer to paragraph 43 of
Yes.
their affidavit.
Okay.
That reads that the deceased's killing sparked widespread public outrage and protest, releasing the accused persons as at this stage risks further deterioration of public peace and order. Well, that's pleasant, Your Lordship. Your Lordship, I have much to say, but I'll stop it at that in the interest of time.
Submissions to your client. You
Very
have
well.
done very well, and you have said it is not because of them, and you leave at that.
Very well, Your
Yeah.
Lordship. I will leave it at that for now. Thank you so much.
Right. We proceed now to for 5 and 6. Yes.
One of 6. Leadership, before I begin, allow me to say my condolences to the family. May God grant peace and justice. So, my leadership, I will begin by indicating that Article 49 to 50 are one of the most important articles in our Constitution. And they speak to the granting of bail and bond and the right to a fair trial. My lordship, the right to a fair trial begins at the issuance of bail and bond. And courts have declared, which I shall not repeat for the benefit of time, in verbatim, that holding persons under unreasonable bail terms or no bail terms amounts to pre-detention. So, my lordship, it brings me to the question of what amounts to or what grounds can be used to grant my clients, the 5th and 6th accused persons, bail. My lordship, all cases have been quoted. I will only quote one that is yet to be quoted. I associate myself with all other cases from the defense team. My lordship, there is the case of Andrew Young Etienne versus Republic, miscellaneous criminal application number 21 of 2017. My lordship, Justice Kimaru in the ruling indicates that the main purpose of imposing bond terms is to secure the attendance of the accused persons before the court and during trial. He continues to state that the terms imposed by the trial court should not be such that it amounts to denial of constitutional rights of the accused person to be released on bail pending trial. My lordship, this supports all the articles of the Constitution and specifically Article 49 and 50. My Lordship, I would also like to speak to the case of Republic versus Paul Dero Obuka, 2015, that was quoted by my good senior and also mentor, Mr. Witt. Yes. My Lordship, in this case, they refer to the primary consideration for cash bail and bond. And the good justice indicates that the primary consideration should be the attendance of persons. All other matters, including whether they have likelihood, security reasons, are secondary reasons. Your Lordship, under these secondary reasons, the court indicates specifically that these has to be proved specifically. Your Lordship, the form we have taken of the production of the affidavit means that anything that the defense, the prosecution has in relation to them denying them bail should have been attached. It cannot be submitted alone. It should be attached. Failure to which it will be presumed that there are no sufficient reasons to deny them bail or bond. Your Lordship, on that basis, I will go to the affidavit to confirm, and specifically to the 5th and 6th accused persons, whether those terms have been met. Your Lordship, we can proceed to paragraph 34. I believe that is page 6. And that speaks specifically to the 5th and 6th accused persons. Your Lordship, it has been indicated.
I don't qualify.
I know, but allow me to do my work.
Thank you.
But then I will only point out to where new facts have been raised.
Yes.
Especially by Mr. Mwono
Yes.
and Mr. Black.
Yes, yes.
Just a few places.
Yes.
But let me start with the affidavit that has been referred to, paragraph 45. A lot of weather has been made unnecessarily by my friend Mr. Black on paragraph 45. A totality of the reading of this affidavit will show that there is a typo on paragraph 45. This affidavit is headed affidavit in objection to bail. So paragraph 45 could not have been intended. And my lady, I keep telling my learned colleagues, bail and bond, that we need, sorry, Mr. Umbeta and Mr. Umari, that increasingly we need to infuse common sense to the law. So a commonsensical approach would tell us that paragraph 45 of the affidavit is a typo, and the intention was that bail should not be granted. Not much to say about it.
Proceed.
My lady, this is my junior in the profession. Ananisomea tu. But my lady, I now invite us, having gone through all this round and round, that we take a point of reflection. And this is why I wanted to refer to what my good friend Ezra mentioned, that for the 5th accused person, he has a child who does not care whether or not is in custody, and who does not want to know, he only wants to get food. Now, right on your left is a father and a mother who, even if they wanted to care, can never see their son. And the son to that deceased was here, unaware of what is going on, that the father can never come back. So that even as we consider Mr. Ezra's submission, that indeed his son does not care that he's in custody and needs food. On the other hand of the balance, a family can never see their son. And a child, I believe the boy is called George, can never receive food from their father. So that's a point of reflection. Just to finish up with the facts that Mr. Ezra mentioned, he tells us that his clients were arrested 4 in number and were released. But on the other hand,
he tells you that he cannot interfere with any witnesses. There were 4. There are 2 in the dock. They are definitely aware of who these 2 other people were. And they can, in self-preservation, reach out to these people. That's all I would want to say about the 5th and the 6th. With regards to the 4th accused person, if I got that right, colleagues will talk about the 4th. Let me go to the 1st, 2nd, and 3rd. But before I leave that, there's reference to the word may, again by Mr. Eza, who is my good friend. My lady, the burden of proof of bail matters is on the prosecution without a doubt. That is admitted. But the balance of proof in bail applications has been consistently confused with the standard of proof. Standard of proof in bail applications has consistently been confused with the standard of proof in criminal trials. In criminal trials, it is beyond reasonable doubt. But the standard of proof in bail applications is merely, and the word merely is used deliberately, merely on a balance of probabilities. My lady, Mr. Ombeta is asking me where that is saying, and I'm sure that the court has thousands of authorities on the standard of proof in bail applications. I don't have to make references. So that if the standard of proof is on a balance of probabilities, then the use of the word may is correct. And that's why, if my lady looks at clause 4.9 of the bail and bond policy guidelines, it more than 3 times says the likelihood. And likelihood is may. Is it likely? Yes. Then it may. That is the word that the guidelines use. And my lady, a lot of, lightweight has been made of the bail and bond policy guidelines. As a student of constitutional law, there's something we call normative derivative. The bail and bond policy guidelines is a normative derivative of both Article 49(1)H and Section 123, capital A of the Criminal Procedure Code. So that it gives life, in the words of Mr. Ombeta, it breathes life to both Article 49 and Section 123A. So the bail and policy guidelines are not wishes. In fact, they have legal normative value. So those guidelines must be taken seriously. So where they say likelihood, then a person from Obunga like me can say may, which is correct. My lady, we agree entirely with the defense that the seriousness of the offense alone, in their words, or merely cannot be a ground to deny bail. We agree. However, for the 1st to the 3rd accused persons, the seriousness of the offense, together with the fact that they are police officers, it is not only the seriousness of the offense, and including all the other compelling reasons that my colleagues will talk. And there's one thing that my learned friend, Mr. Ondago, is a very good friend of mine. I don't know whether he has left, because I'm not talking about people when they have left. If he's not in, I will not mention it. Mr. Ondago.
He's already left.
but then, without mentioning Mr. Ondago, in respect of the 2nd accused person, the gentleman is called Muhwana.
Who else was representing Muhwana with Mr. Wandago? Where is he? He was alone. Okay. There were 2. Yes? Let's
For whatever value this will
yes.
help the court win. On the 20th of June 2025, I was in court together with Madam Nora of the office of the DPP. Mr. Ondago was present in court. And we were before the learned magistrate, I've just forgotten, Honorable Robinson Ondieki.
How can that be brought in?
this is a question of Section 60 of the Evidence Act, that this court can take judicial notice of previous proceedings of other courts. So I'm not creating it. Section 60, my lady.
But let me object to that.
But I have no idea what you know what he's saying, but I don't.
Can a high court take judicial notice of a proceedings in a magistrate?
That's correct. Yes, it can.
It can't.
Unless it is an authority.
Unless it's an authority.
My lady, you know, we can't argue over the law. We can just bring the provision of the law and just read Section 60 of the
this court doesn't have those provisions.
I have not said what I'm referring to yet.
What I think you should do is to give him time to speak.
Correct.
And if he is wrong, after I have heard, I will sustain your objection.
Yes.
Much obliged.
Otherwise, that amounts to bullying. Yes. It is a reply. It is a point of law. It is a point of law.
I'm actually saying this in the interest of James Mukwana. And the people objecting, it may not be to their interest.
Yes.
Just before Honorable Ondieki started reading his ruling on the miscellaneous application, Mr. Ondago, on behalf of Mr. Mukwana, made a request to arrest that ruling. This can be confirmed from the record. Number one, arrest the ruling. And number two, they requested to abandon the application. The respondent is in court, so he can confirm that. Because according to his counsel, they feared for his life. He's here.
That is why Mr. Ondago is not
Mr.
here.
Mani, the person we are talking about, he's seated behind you.
He has to
So my lady, this was not for the benefit of the prosecution, because I had it and I have a duty to this court. This particular applicant had this application made on his behalf. If he has those fears, this court has a duty.
We object. Counsels were here.
You are not representing the second accused, so you will have to let
it in front of us.
Do not raise your voice. Kindly do not raise your voice. This is a court of law, a respected court of law. You can, yes, please, go calmly. Yes.
The reason why we would object to this
is
because if they put it, even if it's on record, counsels may have to reply. We do not have that benefit of putting that reply before him. So that's why we were limiting their replies to fact laws only. If they bring new facts, we will have to reply to them.
My lady,
we do not have
don't rely on this fact, which I'm relying on Section 60 of the Evidence Act. Don't rely on it to the favor of the DPP. Because I had the court summon a probation officer, these are facts that the probation officer can consider. We cannot hide the fact that I was in court when somebody indicated that their life was in danger. I am doing this in his interest, not for the ODPP. I am done with that.
So that we don't go into all this circle.
But he did not. He has not made reference to the first accused, and so I will not take your objection unless you are telling me that you are holding brief for the second accused.
I just perhaps to note something, Your Honor,
yes,
which is very simple.
Yes,
that Mr. Ondago, when he was here and he was making an application to ask for what?
Yes.
For
bail. Okay. What we will do, I will not consider that in my ruling. So we'll just say that.
Let's let it not be considered in our favor, but the court is not that. I don't think it has to be expanded. And my lady, I don't know why counsels are taking over the court's.
Considered it will not be. We were doing very well until then you got agitated. I would ask that you calm down. You are officers of the court. The courtroom is packed. You can see the press has been here the whole day. You are being watched live. The students are watching. Law school students are watching. Take some, some sugar. Yeah. Yes. Very well. Okay. Proceed. So that will not be considered when the ruling, because Mr. Ondago seems to be away.
Yes.
We are.
I've also requested that it doesn't go in our favor, my lady. My lady, as I conclude, 5 years ago, 5 years, 2 months ago, the Court of Appeal, William Wuko, Fatuma Sichale, and Ole Kantai, they were sitting in Nairobi. When they delivered the decision in Titus Ngamau Musila Katitu. Titus Ngamau Musila Katitu versus Republic. And my lady, you have been told severally and repeatedly by this council that we do not know who the witnesses are. But they have told you it is admitted Albert Ojwang died in the police station. Actually, going by the words of Mr. Ombeta, it is not denied that he died in custody of the police. He probably died in Central. I got that right. Yeah, probably was from the Central. It is not denied that Albert Ojwang died at the Central Police Station, at least according to the affidavit. It is not denied that the first to the third accused persons are police officers. And the fourth, though in different circumstances. Do they know, because we are acting on a balance of probabilities, if at all they were present on the material date when this gentleman died, would they know who else was present? Yes. Would those people who are present be possible witness? Yes.
Oli?
Yes, my lady. Where did I lose the code? I'm sorry.
No. I'm okay. You are just too fast.
I will reduce my speed. So if it is possible that the accused persons, at least number 1 to number 3, would know who else was at Central Police Station when they were there, then we have the answer to we do not know who the witnesses are. The answer is we know who the witnesses may be. And may means the likelihood. And the reason I mentioned the Court of Appeal, Court of Appeal decision now comes in. This is what the learned judges said, my lady, which we urge you to be persuaded by. My lady, I'll finish with this paragraph, so allow me to read.
Just go ahead.
The blue code of silence is a common phenomenon spanning across different countries and police cultures in America, Europe, Asia, and even Africa. The blue code of silence. It is the unwritten rule according to which police officers never provide incriminating information about their colleagues. My lady, I know you, the colleague have a chance to respond.
It is a point of law. It is a point of law. It is a point of law. It's reading from a judgment. Kindly pay attention and don't be irritable. In the, you know, the nature of the case itself, has generated a bit of emotions. I'll really ask you to calm down. Just keep attention, pay attention rather, and watch for the new issues they raise. In which case, then I'll allow you to address the same. Yeah, but do not interfere. And I seek permission of everyone here to proceed beyond working hours. By consent of all the parties?
Yes. We have no objection.
Okay, proceed then.
Yes. So the blue code of silence is a common phenomenon spanning across different countries and police cultures in America, Europe, Asia, and even Africa. It is the unwritten rule according to which police officers never provide incriminating information about their colleagues, to close ranks in silence, and to cover up knowledge of a fellow officer's wrongdoing with a collective blanket of self-preservation. A feeling of esprit de corps, that must be French, among officers who by and large depend on each other for their very risky lives as they confront the violent and hostile world of policing and crime. This background is important, my lady, and I urge you that it is also important here in our consideration of this appeal, because the police in Kenya, as we shall demonstrate in this case as in others before it, has in certain circumstances engaged in the practice of covering up for each other. For example, a report by Kenya Human Rights Commission, and it goes on and on and on. We are asking you that the fact that the first to third accused persons are police officers is not an idle fact. It is not. It is an important factor to consider in determining whether or not they shall get paid. My lady, there is no controverting of the affidavit in respect of interference with the CCTV. That is a real happening. Therefore,
My lady, that's not a point of law. Don't go to that line.
I will skip that. Thank you.
Thank you.
In conclusion, at least from my part, this case, despite Mr. Langat's attempt to expand and complicate the principle of public interest, my lady, we invite you that adopt this as the meaning of public interest. And the defense have actually accepted this part, so we'll agree with them at that point.
Which number? Which number?
What are you talking about? Kinyanjui, sorry. Why are you asking me today?
No.
Mr. Kinyanjui, sorry, that was a mistake.
Yeah, but it is sometimes asleep.
Yeah.
You are too dramatic. Instead of the accused persons called Langat. Okay, Kinyanjui. Okay, Mr. Kinyanjui.
Mr. Ondaga's given me a smile that is that, but I've gone on that point.
Because someone texted him.
Yes, because now I'm referring to
Mr. Kinyanjui.
Mr. Kinyanjui has referred to the decision of Dr. Christopher Ndaratu Murangaru versus KACC, which is the predecessor of EACC, and attempted to complicate the principle, the legal principle of public interest. My lady, we invite you, because of the seriousness of this matter. They have admitted that there have been demonstrations as a result of the death. What they are denying is whether that demonstration is aimed at an anger to the accused persons.
It has been called by LSK, the demonstration, so that you deny our client's right to go home. So you can't instigate a demonstration and then use it.
No, Mr. Omar, let him finish.
Yes.
Yes.
I'm not going to allow counsel to misrepresent what I say. I think it's a dereliction of my duty if I allowed that to happen. I did not say that there were protests that emanated from the accused person. That is not what I said. So
sorry, Mr. Kinyanjui is a little rough today. I'm not making reference to the anger.
Not listening.
Yes.
Kindly, the defense counsel, I would urge you to listen. You can see the ladies, all the ladies around have sat very quietly. Kindly, I beg you to listen. Actually, you got him out of context.
The only reference I made to Mr. Kinyanjui is that he complicated the concept of public interest.
Yeah.
And I moved from him.
Yeah.
I am not making reference to what the defense generally have said.
Yeah.
The demonstrations are as a result of the death, but not anger towards the accused, which is what came out. So, my lady, if there is an admission that there has been anger on the death of Albert Ojwang, leave alone aimed at the accused persons. It is reasonable that there is a likelihood that the release of people who are suspected to have been the cause of that death would cause more anger. Likelihood. And my lady, public interest in the simplest form simply means how the public have reacted. It could be an intellectual, academic concept, and I know I'm one of the few people with 2 masters here. We could engage in intellectual discussions of what the concept of public interest means, but at the very bare minimum, public interest means the reaction of the public to an event. So, my lady, I'm not quoting the intellectual bit. I am quoting the simplest on the street. If we went to the Obunga and Buta market, they will tell you that public interest means how we feel as the people. And the people are angry that Albert Ojwang died in the place where he should have been most safe, and that is a police custody. And not with all that, those very many remarks.
Okay.
I hand over to my
only to tell you to withdraw the question of masters.
I have withdrawn.
He might be embarrassed.
I did not hear. I did not hear. The court hears and some it blocks. Did you? Yes. Mr.
That was a joke, my lady.
It was a
yes. I know Mwalimu is here. He was my teacher by osmosis.
Okay. How many minutes, Mr. Ondimu?
Only 2-3 minutes.
Yes.
That last point my colleague has referred to you.
Yes.
I'll refer you to the case of Milton Kabulit at page 21. We had highlighted that relevant part of what he was alluding to on looking at the common person. In relation to the question that my colleague for the fifth and sixth accused mentioned about the general comment, he forgot to read the paragraph that follows later on the presumption of innocence, where the judge stated that the principle of presumption of innocence does not, however, mean that one may commit grave offenses at will and brag that he is innocent until the contrary is proved. It captures what my colleague was talking about. In relation to the question, the last point my colleague talked about on public interest, the case of Milton Kabulit at page 25 through to 26 discusses that particular point at length, and since court has a copy of the decision, to be able to have a look at it, when it really expounds on that particular issue. Maybe that will be all, but just maybe something off record, I would advise my colleague for the fifth and sixth accused to consider whether he will still go ahead and present the two, because from what is emerging that it might cause a conflict, professional conflict. I would advise. It will cause a conflict.
Behind the tent.
Yeah. Yes.
We are four.
You are four.
So
you are four.
For now, we are only.
Yeah. For purposes of bail, it's okay.
I take my seniors' advice.
Yes.
So also, Mr. Omari should know that I also was in the committee that came up with the bail bond policy. I couldn't have. I need to make sure.
The name is so bad.
You didn't allow it.
All right. Now, Mr. Makori. Yes. Yes.
Yes, my lady.
Yes, Mr. Makori, you are the calm one. Please proceed.
Yes, my lady. Just before we finish,
yes,
I'll bring out a point that Mr. Kinyanjui brought out.
Mm-hmm.
That was the issue of competing rights. And this issue had been dealt with in petition number 151 of 2020. I do not have the authority here.
Petition number?
151
yes.
of 2020.
Mm-hmm.
This is the petitioner is CM suing
yes.
on behalf of PM, a minor. There are 9 petitioners versus the AG, the CS Health, and the CS Material.
Mm-hmm. Yes, I know that I have.
Yes, on the issue of competing rights, this is what was said. Equally, this court is making a determination. In making a determination is to be mindful that the proper approach to a violation of constitutional rights challenge is a balancing act between the competing rights. My lady, in the authority, it was observed in a South African court in the case of Gardner vs. Whittaker. Gardner vs. Whittaker, that is in CCT 26 of 1994. And the court observed that it is settled law that there is no hierarchy of rights under the Bill of Rights, and that different rights may compete against each other. Yes, what the court said is the person who seeks to rely on the precedence of one fundamental right over another should bear the honors of establishing the basis for such precedents. My lady, we respectfully submit that that has not been done. Yes, my lady, with that point, or rather at that point, we wish to end our submissions. That what we have come here to do is to ensure that justice is done to the nothing else. No politics. Come to cool any tempers or to play politics in this matter. We are simply coming here to present the facts. I will withdraw that. Avoid that. Okay. Yes. Lastly, my lady, closing remarks. We are grateful for this opportunity, for your resilience. You have been with us from morning till now.
Will be submitting.
Very well.
He's giving thanks on behalf of the state. It is right. It is right. The state should appreciate.
Yes, I don't know why the LSK is unhappy with that.
My lady, I had to stand on my feet at some point during submission. We have to provide something.
Oh, you wanted to say something?
Yes.
Do they have a right?
Yes. Directly.
Willie Kibera, once the DPP has responded, they have no say in response. And we will challenge that Clifford's in that matter. Justice Leslie, they have no right once the DPP. What I'm saying, the DPP once he has done a rejoinder, it's final.
No, you will sit. You will sit. I'm watching the whole lot of you embarrass yourselves.
Yes.
Yes, I'm watching the whole lot of you embarrass yourselves. Mr. Makori is on his feet. Professional ethics. What did you learn at law school? When one is standing, you keep quiet. Yes, you sit. There's nowhere to sit, so we just keep quiet. Yeah. Mr. Makori, proceed.
Yes, as I said, that we are grateful.
Yes.
And for the resilience and for you being patient with us. You have had our submissions from morning.
Yes.
And we also wish to thank the media. And we also wish to thank our colleagues, so the LSK, who have come to support us. And last but not least, we also appreciate the sentiments or arguments from the defense. With that, my lady, yes, with that we end our submissions. We have a list here of the contacts of the advocates. Please do write your name and contact.
Yes.
Before, yes, we'll be rising up after you've made directions, just on small issue. Yes, yes, that.
Maybe now that my senior Mr. Makori has sat, again, I did not wish to object given your direction that at least we allow him to speak. Now, my colleague Mr. Makori has made reference to, in his submissions, competing rights. And my lady, I'll be doing a disservice if I kept quiet, because I'm the one who submitted on that issue. And my objection is only one. My lady, when I was submitting about public interest vis-a-vis fundamental rights and freedoms, we started from the premise that
I'll only write when I feel that you have raised an objection that actually counters. Because you see, he was submitting on points of law. So yes, he had the right to quote that authority. And the authority speaks to competing interests and competing rights, even if you did not allude to the same. Yes.
The authority was speaking about competing rights. The whole thesis is about competing rights. But the premise that we began with, and which is indeed the correct position of the law, is that public interest is not a right. It is a legal principle.
And I put that on record. I will choose in my ruling either to agree with you or to agree with him or disagree with him and agree with you.
Most of them.
Yes, that is why the court now will take, you don't need to worry about that. Yeah, that is the law as he interprets it. Yes, and that's the law as you've interpreted it. Now the court will give its view. Now, you want to make closing remarks?
Yes. On behalf of the defense team, we sincerely appreciate the expeditious nature this matter has taken. It came today. Plea has been taken. And bail agreements have been done. Well, this will set a precedent authority on many matters, whereas defense team accused take plea, and a year down the line, the question of bail has not been settled. We appreciate this industry. In my practice and Mr. Cleve's practice, this is the second matter in the history of this republic. The first one was when we appeared in Mombasa in Aisha Juma. We argued and the court made a decision in a day. We appreciate our colleagues from the state for the industry that they are put into this matter. We appreciate colleagues from the Law Society of Kenya for the effort and the type of presentations they have brought before this court. Condolences that we are only doing our job. May justice be done to Ojwang'. That's all on behalf of the defense team.
Right. No, you will sit. It is you first for the victims. You will, yes. Yes. We are not done with the defense. Sorry. Mr. Please calm your face. You are angry. You are angry. And let's go back to the Constitution. Prosecutorial powers are vested in the DPP. And the DPP is happy. You are the supporting team to the DPP. Now, when you start glaring at the court, looking at me, frightening the court, you...
My lady, on his behalf, I have smiled.
No, it is not proper. It's not proper, and I think you'll have to sit with the DPP and agree on this approach.
Yes.
There is that limit. The court has given you latitude. You have made lengthy submissions. Now we are taking closing remarks, and not all of you have to make closing remarks. And that's why Mr. Omari could have done it for the defense. But Mr. Wandago is burning to say something.
My lady, the reasons to why I'm burning to say something is that
yes,
there are amendments that were made in my absence.
I even brought an order that I will not even mention the submissions that Mr. Owiti made in my ruling. So you have not been, you've been misinformed.
In the circumstances, my lady, I just wish to appreciate the prosecution side. family. And while I'm still on my feet, my lady, I would add the court while making giving directions, this is my lady, that you direct that the second accused person, you have the discretion to direct the second accused person to be detained at the capital union station. Maybe when awaiting the mental assessment. Another reason for the detainment at the capital police station is that we are currently in talks with the prosecution and we want a situation whereby we can access him at any time. When detained when remanded at industrial area or whichever prisons, my lady, it will not be easy for the defense counsel to access him. For those reasons, my lady, I'll be praying that he be detained at the capital police station. That's all.
Okay, the rest of you who want to make closing remarks, I think Mr. Omari has made remarks on behalf of the defense team. I will go to the victims. You want to make some closing remarks?
Yes,
and the name again? Yeah, Julius Juma, yes.
You'll allow me to make closing remarks on behalf of the victims and on behalf of my colleagues who are supporting me. I thank Your Honor for the industry that you have shown in this matter. You do not even want to rise for end the break that will come from this end. We appreciate that, Your Honor. I appreciate my colleagues for the prosecution, my colleagues from LSK and colleagues for the family, for the industry that they have demonstrated this day in this matter. And I will also not ignore my colleagues from the defense. Like they have said, which I understand and which I will explain to my clients to also understand that they are just doing their job. Today they are there, tomorrow they will be on the other side. We thank everybody for the roles that we have played, particularly today in this matter. We wish to inform you, if you want to know, that we shall lay the deceased to rest on 4th of July, that is next week, Friday. And you are all welcome to come on the rest. So help us lay to rest. Thank you very much.
Right, thank you very much. And now that LSK president was here in person, someone to speak for the LSK president, and it will be the lady. He's too angry. Stand, rise and speak. Rise and speak.
Thank you.
Yeah.
Thank you, my lady.
Yes.
For the opportunity.
Your name again?
Miriam Oma, LSK.
Yes.
We want to do closing remark, and also we apologize earlier for speaking when Senior was on his feet. There were some issues that were raised, but we wished not to touch on them, but rather to just say thank you on behalf of LSK.
You can only speak if you are dissatisfied. You can rise and say for the victims, there are issues that the DPP did not cover, which we need to cover at that when you are interjecting. But I believe at this juncture, just with the rejoinder of Mr. Ondimu, the new advocate, State Council Makori, and yes, I think he has spoken for all of you, the victims, and I think I've done very well. I've given you sufficient time. Please calm your faces. Yeah, if anyone should be having a gloomy face, it should be this side, because they are mourning. The rest of you, you need to support the court to be strong. Thank you, madam. Yeah.
Thank you so much.
Issues were raised, but I think I do not want you to reply. Kindly let it lie. I think, yes.
Thank you. I'm just not replying as you directed, but rather just making a request. that there be a pre-bail report assessment to be done so that to assist the court and also to capture the sentiments of the victims.
Beautiful.
Thank you so much.
Okay. Here also, you all agree that we cannot do it. You want to say something?
No, just to add to what the second accused
Mr. Wandago?
counsel said.
Mr. Wandago, not Wandago.
The proceedings will just show it's Wandago. Sorry. Yes?
Yes, we are in support of that application for the second accused person to be remanded at Capitol Hill Police Station. There are still some bit of investigations which are still ongoing. It will be easy.
The head of probation, are you in court? Probation Kibera? Yes, come forward. The practice of this court is always to have the patient the whole day. That's what we've been dealing with. Now, these are 6 accused persons. How many days do you require to prepare the pre-bail report?
The lady give us 1 month and 2 weeks.
No mamas, no mamas, the court is writing, you are interfering with the flow of thought.
The lady afraid.
Yes, I heard you. I'm talking to my friends around this corner, they are murmuring. Modus operandi. Once plea has been taken, all accused persons are remanded in prison and not at police stations. Police stations are temporary holding cells where suspects are held for 24 hours before arraignment. Suspects may also be held for a longer period pending investigations where a miscellaneous application has been filed. That is not the case before me. I would therefore decline the invitation to have the 1st, 3rd, 4th, and 5th accused persons to be detained at the relevant police stations. However, the 2nd accused person shall be detained at Capitol Hill Police Station because the prosecution have no objection. Secondly, all the accused persons must be subjected to mental assessment, which is a good practice to establish whether they are fit to proceed with the hearing. That can only be done when the accused persons are detained or remanded in prison. It therefore follows that the investigating officer, and where are you? Raise your hand. The investigating officer, you have the duty now to escort the 2nd accused person to Mathare Mental Hospital for mental assessment. The rest of the accused persons, 1st, 3rd, 4th, 5th, and 6th, will be escorted to Mathare Hospital by prisons officers. Finally, the probation officer is directed to prepare a pre-bail report to guide this court before a ruling is done. This matter shall therefore be mentioned after 1 month and 2 weeks as requested by the probation officer, and I'm going to give you a date. And just to add that accused persons must know that justice moves very slowly. 4 of you are police officers and you have interacted with the justice system. It does not fly like a Concorde. It actually moves like a tortoise, and that is why tortoises have never been known to have accidents. I will therefore request for your indulgence to allow me to do my work, and I'm giving you a mention of which date, Nelson. Which date? Yes, there's a vacation, but 1 month takes us to 24th of July, so that will be 30th. We can give the 30th of July. 30th of July, produce the accused persons physically. That is how the criminal justice works, and I'm very, very sorry for the orders. I see you looking at me with fallen faces. Here, Nelson.
Melody, before you can also.
Yes. Yes.
The information we have says that copies of the evidence which the prosecution intends to adduce to your trial
here
are attached here.
Here. Or we were not able to print. We didn't print anything.
That's what I'm saying. We wanted the state to tell us.
Yes.
We can pick those now because we want the accused people.
That was the reason why I was asking for your numbers.
Can you exchange? Can you do the exchanges so that when we come on 30th we can also do pre-trial?
Yes.
No, but it will be directions and pre-trial.
Yes, I was asking for their numbers and emails, and only 12 of them are provided.
Yes.
So we'll only be able to send to the 12 provided.
Yes. Attention, everyone, please, can you share your email addresses? That is the end of today's proceedings.